Well, welcome everybody to the second day of these impressive deliberations that we are beaming live on YouTube and I think Facebook. I didn't hear anything about TikTok, so I'll hold my fire on that front. My name is Dino Kritsiotis. I am a professor of public international law at the University of Nottingham, where I co-direct the Center on Security and International Law, and I'll be chairing today's first panel. It's my great pleasure to be moderating the first of the two panels that we'll be having today, which follows what I'm sure you agree is a very helpful set of presentations and exchanges from yesterday. To recall, these concern the basic legal status of Crimea and Donbas, as well as the relation of humanitarian law and human rights in occupied spaces. Today, we shall be taking a few more steps in this area of study in international law. I'm very grateful to Global Rights Compliance for bringing us all together in this way. But I'm especially grateful too for the point of focus that they have given us for this morning's deliberations, which is obligations in relation to specific populations affected by the conflict. We cannot elide this factor of the trauma or indeed the inherent terror of warfare. How for civilians, violence it has to become the routine of the everyday. I'm put in mind of one of the poems of the Odessa-born poet, Yuliia, from his collection, Deaf Republic. It's a fantastic collection, which tells a story about the human impact of war. And the poem that I'm thinking of is entitled, quite simply, 4 a.m. Bombardment. And it speaks of him seeing the blue canary of my country pick breadcrumbs from each citizen's eyes, pick breadcrumbs from my neighbor's hair, how the blue canary of my country runs into walls, into streetlights, into loved ones. The blue canary of my country watches their legs as they run and fall. It's a very powerful way of demonstrating how warfare has this regularized impact. With these poems, we are put in mind or in the midst of a story that involves the killing of a deaf child by a soldier, and how in response, civilians feign deafness as an act of resistance. The human ear suddenly becomes a barricade to the acts of intimacy and violence. But what is it that the ear does not or will not hear? We really are very fortunate to have 4 superb speakers who will guide our thoughts and thinking on such matters, all of whom I am sure will keep professionally to the 10 minutes that have been allocated to them. But as I said to Amal at the head, we are humanitarians, so there will be some leeway. At the end of the 4 presentations, there will be a chance for you to pose your questions via me as chair, as we did yesterday. But please feel free to formulate these and send them to me in the meantime. This can be done by using the chat function, which you should be able to see on your Zoom panels right at the bottom. I shall now introduce each of our 4 speakers in turn before each of them takes the floor. First up is Neve Gordon, who earned his BA in philosophy from the Hebrew University of Jerusalem and his MA and PhD both in political science from the University of Notre Dame. Neve is Professor of International Law and Human Rights at Queen Mary University of London, and most recently is co-author with Nicola Perugini of Human Shields, A History of People in the Line of Fire with the University of California Press. This really is a most informative and insightful text, which join his many other important and enduring interventions in the field of international humanitarian law, amongst which I should call out Israel's occupation, which was published in 2008. Neve will address the topic of human shields and the location of agency. Neve, we're delighted to have you join us. And it's now over to you.
Thanks so much, Dino, and thanks for to the organizers and other participants. I'm going to share a screen very quickly. So I guess you can see this. So human, just 1 second. So Human Shields is a book that Nicola and I wrote and came out a few months ago. And we're basically trying to tell the history of Human Shields through this book as a history that we use the human shield as the protagonist of the book, but the book itself is actually about how international law allows for humane violence. And the human shield is a very interesting figure to examine international law, we think, because it does not really sit well with the two axiomatic figures of international law, which on the one pole has the combatant, which is someone that according to the law you can kill. And on the other side of the pole, you have the civilian, which according to the law must be protected. And the combatant is imagined according to the law as a figure that is active and is participant in hostility through his or her activities, while the civilian is imagined according to the law as a passive figure who is an innocent bystander. And the human shield is actually an amalgamation of the two, because on the one hand, it is the human, and in that sense, it is more like the civilian and calls upon us, maybe to cite Dino, to be humane and to act in a humane way towards this person. But on the other hand, the human shield is also a weapon of war. It is a shield. And in that sense, it fits more on the combatant side of international law. And so what we claim is that the human shield is a threshold figure that does not fit any of the two poles. And in many ways, international law does not have the vocabulary to deal with human shields. And it exposes a lot of the difficulties or some of the power relations within the law. But this is how the law defines human shields. The presence or movement of the civilian population or individual civilians shall not be used to render certain points or areas immune from military operations, in particular in attempts to shield military objectives from attacks or to shield, favor, or impede military operations. Now, much can be said about this definition, but I would like to just highlight two issues. One is the presence or movement of the civilian population or individual civilians should not be used to render. Used, as you will see, the agency here is not the civilian, but is someone else, and the civilian is passive. But what this also tells us, it shall not be used, meaning it is illegal to deploy human shields. So on the one hand, the law avows the illegality to deploy human shields. On the other hand, the law tells us that it will not make the area immune from attack. So it is illegal to use human shields, but also we can kill human shields. Okay, so the law relaxes some of the protections that it offers civilians in cases of human shielding. Now, there's basically three types of human shields: involuntary human shields, voluntary human shields, and proximate human shields. And the law does not really make these distinctions. And for the most part, it is discussing the involuntary shields. And what the distinction between these three different shields is based, we claim in the book, on the location of agency. Where is the agency in each case? Okay, so if we look at the case of Dar Farouk, Indian citizens from Kashmir who was tied to a jeep, like you see in the image here, and the jeep patrolled the towns for maybe 5 hours, and he was used by the soldiers to protect, or ostensibly used by the soldiers to protect the jeep from angry civilians throwing stones. So the agency here is not with Farouk, but actually with the soldiers that tied him to the jeep. The second kind of human shielding is a voluntary shielding. This is an image of Rachel Corrie in the Gaza Strip, and basically what the agency here is with the voluntary shield. And what we understand here and in the image before, that human shielding is actually a politics of vulnerability, because it is not the force or the power that the human shield has which helps it deter an attack, not deter, but the aim is to deter an attack. But it is actually the vulnerability of the human body that is used, and the moral claim that it kind of makes to the enemy: do not kill this vulnerable body. And it can deter or not deter. Now, what we see in many areas around the world is that the history of human shields in our book is also a history of the human body and a history of the hierarchy of the human body. And so the human body, not in its biological sense, but in its political sense, has a hierarchy. And it is not coincidental that Rachel Corrie, a white woman with a passport from the United States, has more and is privileged in relation to the people that she is trying to protect here in Rafah, in the Gaza Strip. And so she basically has more value in the eyes of the soldier than the people of the Gaza Strip. So she is using her value and her privilege as a white American in order to try to stop an attack. We all know that she did manage to stop a few attacks, but ultimately she was murdered by the driver of the bulldozer. But what is important here is that the fact that she can use her own body as a human shield tells us that she has some privilege. And to complicate that, she is on the one hand very courageous, using her privilege in order to stop an attack, but on the other hand, she is reinforcing that privilege at the same time, because she is asserting her privilege and reinforcing a certain hierarchy in the international arena. But what we see here, if I go back to the whole issue of agency, what we see here is that she has the agency, and when she stops serving as a human shield, then the Human Shielding Act stops, and she becomes a civilian again. I'm gonna jump this and go directly to the third kind of human shielding. In a study Nicola and I carried, what we found that over a period that we looked at the mention of human shields in newspapers, our major newspaper publications around the globe, we found that about 99% or 98% of human shields that are mentioned in the articles are neither voluntary shields or involuntary shields, but they are what we call proximate shields. Proximate shields are shields that are trapped in urban zones, because most of the fighting today in the world takes place in urban settings. So you have a city with several 100,000, sometimes millions of people in it, and there's fighting taking place in it. And by definition, once the fighting takes place in the city, there is proximity between the protected civilian actors and the combatants that are fighting. And this proximity, we claim, is being used to basically cast the whole civilian population as human shields. So what we have is the disappearance of the battlefield, and in the battlefield, this distinction between combatant and civilian, which is arguably the bedrock of international humanitarian law, disappears, because you cannot have that distinction, or it is very, very difficult to sustain that distinction in a city. And what we see is how the forces that tend to attack cities tend to frame the civilian population as human shield. Now, that framing is very important, because once the civilian population is framed as a human shield, it means that the militants that are hiding in the city carried out a war crime, because it is illegal to deploy civilians as human shield. And if let's say I'm attacking the city, if I attack the city and kill civilians while I attack, I cast them as human shield, and then the blame for their death is not on me, but on those that deployed them as human shields. And
Neve,
so
can I ask you to start bringing the presentation to an end?
Yes, so I'll just end with this. What we see here is basically the days before the attack on Mosul, and the United Nations comes out with a press release, ISIS, and you have at the time a few hundred fighters in ISIS in the whole city, holds 100,000 human shields in Mosul. Now, they do not need agency to hold 100,000. It is merely their proximity to the civilians. The whole civilian population is cast as human shields, and that allows and creates a situation where the civilian population becomes more killable. Now, I haven't finished, but I'm going to leave it at that, because in the interest of allowing the other speakers to speak, but I'll be happy to answer questions in the Q&A. I'm going to stop sharing my screen now.
Great, Neve, thank you for that excellent start to our presentations. Also, with the very helpful images that create a separate point of focus for us, driving home the various categorizations and taxonomies that you were developing in that presentation. Our second speaker is Yuliia Gorbunova. Yuliia's bachelor's degree in law is from Tyumen State University in Russia, and she also holds a master's degree in professional communications from the University of Western Sydney. At the present time, she is Ukraine and Russia senior researcher in Human Rights Watch's Europe and Central Asia division. Her particular engagements have concerned the crisis in Ukraine, especially in the Crimea, with concern on enforced disappearances, the prosecution and detention of Crimean Tatar and pro-Ukrainian activists, as well as abuses undertaken by paramilitary groups. All of this by way of preface to her presentation for us today, which is entitled The Tatars and Prisoners. Yuliia, a warm welcome. Lovely to have you with us. You have the floor.
Thank you very much. Thank you for having me. It's a pleasure to be speaking on this panel. I've been asked, in fact, to speak about the situation of Crimean Tatars in occupied Crimea. And I would like to start by saying that Human Rights Watch researchers and myself have been on the ground in Crimea from the very beginning of the occupation. And we've published dozens of reports to make sure that voices of people who live through human rights abuses in Crimea are heard widely, heard by policymakers, and also we did that to try and amplify work of very courageous lawyers, human rights defenders and activists who living in Crimea in smaller and smaller numbers and continue to put their safety and their liberty on the line. I would also like to say that Human Rights Watch has a long-standing policy on laws of armed conflict, according to which it remains neutral on military occupation of another country. So Human Rights Watch does not take a position on military occupation of another country. However, like many other international organizations, we seek to ensure that international laws that govern conduct of war and occupation are respected. And once we have made a factual determination that situation in Crimea was in fact an occupation under international humanitarian law, also like much of international community, we found that since Russia occupied Crimea and began transferring its and applying its legislation, including very repressive legislation in Crimea, it has severely curtailed human rights protections and violated its obligations under international law as an occupying power, in particular as concerns its obligations to protect civilians' rights. I'll go very briefly over those obligations and the laws of occupation. And as I speak, I will give examples of where exactly violations occurred, although there was too many to name them all, of course. Under laws of occupation, Russia has an obligation to restore and ensure public order and safety as an occupying power, as far as possible, while respecting, unless absolutely prevented from doing so, Ukraine's laws prior to March 2014. Russia is also responsible for upholding order and for violations under international humanitarian law and human rights law, which were committed by local authorities or proxy forces, and has a duty as an occupying power to prevent and prosecute such violations. And lastly, it's important to remember that all international human rights law remains applicable in Crimea. and that includes all treaties that were ratified by Russia, such as European Convention on Human Rights, International Covenant on Civil and Political Rights. From the very beginning, Russia has thoroughly persecuted people critical of the occupation. It used a very wide arsenal of tools to do so. And they included, of course, disappearances, false prison charges, harassment, intimidation, unlawful expulsion, barring people from entry. And Russia particularly targeted Crimean Tatars as a peaceful and unified and very strong voice from the very beginning, which was consistently critical of Russia's actions in Crimea. I'll give you a few examples in a timeline which will show how that persecution grew and intensified from March 2014. In the spring of 2014, authorities failed to rein in paramilitary groups that were effectively running the peninsula at the time. They were implicated in grave human rights abuses, including torture of Crimean Tatar activists and basically all people and activists who were perceived as supportive of Ukraine and critical of Russia. Authorities barred Crimean Tatar elders, starting with Mustafa Dzhemilov, who is the leader of Majlis, Crimean Tatar representative body. Mustafa Dzhemilov was banned from entering Crimea in 2014, and that ban was recently extended to another 13 years. Russian authorities started very deeply coercive passportization process, where they effectively forced Crimean residents to either accept Russian citizenship or declare an intent to keep a Ukrainian citizenship. However, this was done in a way which did not establish clear procedure for, first of all, for attaining Ukrainian citizenship. The timeline was very short to do so, and effectively that led to people who retained Ukrainian citizenship becoming foreigners in their own homes, people with no rights, which is also a violation of laws of occupation. Russia very quickly started applying its vague and overly broad anti-extremism legislation in Crimea, and that process only have intensified since then. Authorities started by issuing a series of warnings, anti-extremism warnings to Crimean Tatar bodies such as Majlis. And then they conducted several waves of very intrusive searches, and I witnessed some of them. And I also interviewed families that went through that, and it was a terrifying experience where dozens of armed men in masks would show up at early morning at 5 a.m. And wake up the kids, break into houses, looking for what they said they were looking for: drugs, prohibited literature, and weapons. Such searches were conducted also in Islamic schools, madrasa, and in mosques. Authorities also banned almost immediately all gatherings, including commemorative gatherings for Crimean Tatar community, harassed continuously Crimean Tatar media outlets, refusing to re-register them under Russian laws, issuing multiple anti-extremist warnings, and eventually and effectively pushing them out. And finally, authorities started dozens of criminal proceedings against Crimean Tatar activists on trumped-up charges of extremism and terrorism. And using terrorism charges against Crimean Tatar community actually proved to be an extremely convenient tool for Russian authorities to stifle dissent, because on one hand, there's already a very established practice of using these charges in Russia. And so the practice, the experience and legislation was already there. And basically what the authorities did is that they framed all activists, so members of Crimean Tatar community that they wanted to effectively silence as affiliated with Hizb ut-Tahrir, which is a pan-Islamic movement that seeks to peacefully establish caliphate, but it does not espouse violence to achieve its goals. And that movement is and has been legal in Ukraine and most European countries, but is prohibited in Russia. Again, that's a violation of laws of occupation because Russia does not have, as an occupying power, cannot impose legislation that contradicts laws that were in place before the occupation. These charges of affiliation with Hizb ut-Tahrir have been applied both to actual members of Hizb ut-Tahrir and perceived members of Hizb ut-Tahrir, and they're serious charges. They draw very long prison sentences, as long as 19 years. Some people are serving them. Most people are serving them outside Crimea, which is also a violation of laws of occupation because it's basically equivalent to deportation. In total, there are 80 people that have been arrested on these charges, and so far 34 have been sentenced to extremely long prison sentences. It's also important to note that none of the people sentenced have been accused of any violent acts, participating in violent acts, preparing violent acts, carrying out any act of violence. And we also documented more searches, more waves of searches similar to the ones I described earlier on charges of extremism and terrorism more recently, where we have documented cases of authorities using planting evidence and using torture to people to force them to confess. And finally, I would like to point out that very grave human rights abuses that took place in 2014, which I briefly mentioned in the beginning of my presentation, were enforced disappearances. And the majority of those cases in early months of the occupation were Crimean Tatar activists, including the case of Rishat Ametov, who was forcibly disappeared with the so-called self-defense units implicated the paramilitary forces that were running the show at the time. There's video footage of them taking him away from a protest, a one-man protest, effectively a picket. He was later found dead, and with his body bearing signs of torture. And there have been in total 43 cases of enforced disappearance documented by OHCHR mission in Ukraine. This includes 39 men and 4 women. And that comprises 11 people that are still missing. There haven't been effective investigations of any of these disappearances, even though majority have occurred in, as I mentioned, in 2014.
Yuliia, can I ask you to start wrapping up, please, your presentation?
Sure, yes. In fact, that's really the last point that I wanted to make, and I'm happy to answer any questions. Thank you.
Great. That was really excellent as well. Great exposition of the silencing and suppression that's been taking place in the framework of the occupation, which picks up on many of the themes of yesterday that we heard. So thank you very much for that, Yuliia. Our third speaker to join us is Elina Shyshkina, who holds a doctorate in public international law and was trained at the House of Commons of the Parliament of Canada and at the European Court of Human Rights. She was a member of the Parliament of Ukraine, of the 6th convocation, which was 2007 to 2012, and has over 15 years of professional experience, including state functioning, political activity, program management, legal analysis, and advocacy work. She specializes in the protection of human rights, especially for conflict-affected persons. So this is a terrific panel for her to be joining. In July 2017, Dr. Shyshkina joined the charitable foundation Right to Protection as a legal analyst on housing, land, and property issues of conflict-affected persons, and very recently was promoted to the role of advocacy coordinator. The concern of her presentation will be internally displaced persons affected by hostilities, a much neglected topic, if I may say so. And I believe the presentation is going to be delivered in the Ukrainian language. However, there will be a simultaneous translation in both directions, that is from Ukrainian into English and English into Ukraine. But in order to avail yourself of the facility of translation, you will need to turn on your translation button in Zoom, which is at the bottom of your Zoom panels, and you will either click into the relevant language. I think we're all set. Elina, please can I invite you to deliver your presentation?
Thank you so much. Good morning, colleagues. First of all, I'd like to say some words in English that I am very grateful to you to invite me to make a speech, to make a presentation in this very valuable and useful international legal conference regarding occupation of Crimea and the armed conflict, armed aggression in Ukraine. Я буду говорити дійсно українською мовою і
Yes, indeed, I'll be speaking in Ukrainian. And first and foremost, I would like to say that our today's panel is dedicated to the topic of the commitments of the states, including commitments of Ukraine as a state with regard to conflict-affected persons. And first and foremost, I would like to say that in the international level, when it comes to the issues concerning IDPs and the rights of internally displaced persons, there are certain acts and regulations of international organizations and principles of international law. For instance, we may refer here to the UN guiding principles on internal displacement, also report on housing and property restitution in the context of the return of refugees and internal displaced persons, and also the regulations of the Council of Europe. The aforementioned regulations are the norms of the soft law, and quite often they are of non-binding nature. It means that these are the recommendations to the states that are supposed to be applicable in the national legislation in order to protect the rights of conflict-affected persons. At the same time, we should bear in mind that these provisions are aimed at settling certain issues that are not settled in the international treaties. On the other hand, these soft law provisions are also aimed at the elaboration on the commitments of the states under international humanitarian law and international human rights law. This sort of commitments in general terms mean that the state is obliged to provide protection to those persons who have been affected by the conflict and to mitigate those consequences that came into effect due to displacement. And this is in line with Principle 3 of the UN Guiding Principles on Internal Displacement. In general, this sort of commitment stems from a range of other obligations that are also set out in the UN guiding principles on internal displacement, but they are not set out directly. That are set out by means of the rights of internal displaced persons, like a right to life, a right to dignity, right to property, right to education, right to health, right to be fully integrated into the hosting communities, etc. We should bear in mind that the human rights also have to be matched with the responsibility of the state. It means that if we do not have the direct reference to the commitments of the states and obligations of the states, they still are correlated, they are matched with these rights. And it means that there is a set of obligations of the states that stem from their commitment to protect people who are within their jurisdiction, those persons who were affected by the conflict. And it doesn't matter whether the state is the victim of belligerent aggression, like in the case of Ukraine, or whether we are talking about different type of conflict. There is an obligation of the state to protect its citizens who have been displaced and who have become internal displaced persons. Speaking of the national norms and legal framework in terms of IDPs, the national law should be based on the international treaties setting out the commitments of the state, but also the soft law regulations that are aimed at the development of these treaties and their enforcement. Even though they are of non-binding nature, they are still the roadmap for the direction in which the state should be headed. What needs to be done to protect the IDPs? And now getting back to Ukraine in particular, we may conclude that in my work, in my advocacy coordination, I noticed that there are a few approaches when it comes to the correlation between soft law and national legislation. Well, the practitioners, they are using the soft law norms and they are very much interested in Ukraine being able to fulfill its obligations. And it means that the regulations of the soft law should be taken into due consideration while drafting national legislation. But there is another approach that is more favored by the governmental officials. They believe that soft laws are of non-binding nature. They are more the guidelines and recommendations rather than the binding norms. But if we have a look at the national legislation of Ukraine, we may notice that it encompasses both international commitments according to the international humanitarian law and international human rights law, but also it contains certain regulations and provisions from the soft law. But getting back to that, I would like to say that there are some ambiguities with regard to it. Starting from 2014, when Ukraine sustained the big wave of internal displacement with the high number of internal displaced persons moving inside the country. Some issues emerged that are not resolved until now. Partially, those issue settlement was reflected in the national law, but not all of them have been settled. For instance, we may note that the housing right has not been fully exercised. It means that IDPs are entitled to take part in some special programs to be able to buy housing. For instance, to be entitled to mortgages with low interest rates to be able to buy housing. But housing is the biggest issue for the IDPs since it is directly related to the way they are integrated into the host communities. If they have the place to live, if they have the work, it is much easier for IDPs to be integrated into the host communities and to be able to function and go about their daily life. That is why settling the issue of housing is one of the crucial ones, and it requires comprehensive approach, not just the legal framework, but it also requires the respective state programs and proper funding to it as well. Another issue is the social protection of IDPs and pensions. Since there is certain dependence of IDPs on their certificate of being IDPs, they need to be able to present it all the time to be able to get certain benefits and services. Besides, this certificate is also required for the personal identification to get access to healthcare services and other services that are provided by the state of Ukraine currently. In many cases, IDP certificate is required to get access to certain services. Speaking of the housing programs, IDPs are entitled to take part in those programs if they present the certificate of IDP. With regard to this, there are some questions, as in order to untie the certificate of IDP from the right to get pensions, but unfortunately those two are very closely tied at the moment. Another issue that arose from the displacement, the electoral rights, voting rights of IDPs. The IDPs need to be able to vote in the elections, and this matter has been resolved in 2020. IDPs were able to vote in the presidential elections and also to vote for the parliament based on the party list system. But when it comes to the local elections, the local councillors, the local mayors elections, until 2020, IDPs were divested of this right in Ukraine. Only last year, the respective amendments were introduced into Ukrainian legislation, and their active and passive rights were recovered and resumed. This is one of the success stories for IDPs' rights. One more challenge and one more issue that needs to be addressed, this is the integration of IDPs into the host communities. As I have already mentioned, it means that there are certain issues in terms of the access to housing, access to healthcare, access to services. We know that certain steps have already been made, but still there is a lot of work ahead of us. Speaking about legislation, in Ukraine, there is the comprehensive law for ensuring rights and freedoms of internally displaced persons that sets out the protection for the rights of the internally displaced persons being protected. But there are certain flaws in this law. These flaws have been detected 6 years ago since it's been in effect. And these flaws are the following: the access to services, equal opportunities for the host community members and IDPs, access to local decision-making process, etc. Currently, from the formal point of view, IDPs remain invisible for the local authorities, since from the formal point of view, they are not the citizens of the community and they are not registered within this community. This is one of the issues that also needs to be resolved, the registration of the place of residence. Since they are not registered in the community, their residence over there is considered as non-permanent, temporary, and it has also legal consequences. I would like to mention draft law 4487 that has got the positive opinion of the respective committee of the parliament and is to be reviewed in the parliament in the nearest future. This is the bill to update the law on the rights of IDPs. And to conclude, I would like to mention what are the overall issues with the Ukrainian legislation when it comes to the rights of IDPs. I would like to outline the matters of a more general nature. In many cases, we do not have the proper legal framework, like in the case of voting rights, but at least this matter has been settled in the legislation. But for 6 years, IDPs were banned from taking part in the local elections. Fortunately, this matter has been resolved. Another issue is the jurisdiction. And when we have the legislation for IDPs, quite often the provisions are articulated in such a way that there is some ambiguity allowed, and it means that the legal practice quite often is not the same depending on who is interpreting the norms of the law. And the third matter that is of concern, this is the discrepancy in the bylaws. And quite often there are some contradictions between the bylaws and between the law, like in the case of pensions for IDPs. Summarizing my input, I would like to emphasize the following. First and foremost, the obligations of the states are incorporated not just in the international laws and treaties, they may also be incorporated into the soft law regulations. In national regulations, we may not just take into consideration the international treaties. We may also apply the soft law to be more efficient in our actions. And another conclusion of mine is that the national law in terms of the IDPs requires improvement and refinement with the use of international norms. Thank you very much for the opportunity given to me, and I'd be happy to respond to any questions.
Elina, thank you very much for that wonderful, wonderful presentation. It was very full of points of law in terms of regulating treatment of IDPs, and actually throwing up for all of us the nature, the range of challenges that are faced by states. So that's a fantastic presentation to have. If I may, can I also thank our translators who you've given a good challenge to. I very much appreciated having that in English. So thank you to the presenter and to the translators. Our final speaker for this panel is Amal Nassar, who is a consultant at the Global Survivors Fund, which aims to enhance access to reparations for survivors of conflict-related sexual violence, and a sexual and gender-based violence rostered expert at Justice Rapid Response, which is a network of criminal justice professionals who can be deployed to investigate, analyze, and report on international crimes and gross human rights violations. Amal has worked on the documentation of a series of international crimes, including those committed against children in Syria and Iraq, also very much neglected topic in my view. But she has also worked on access to justice and the rights of victims and survivors in an array of jurisdictions throughout the world. Previously, Amal has worked for several civil society organizations, including the International Federation for Human Rights and the Coalition for the International Criminal Court, which closely follows other work that she has been doing. She has consulted with various international and national organizations, including UN Women, the International Independent and Impartial Mechanism for Syria, and Madre. Amal has published on sexual and gender-based crimes, which will inform her presentation today. Its title is Sexual and Gender-Based Violence and Gendered Aspects of the Conflict in Ukraine. Amal, a warm welcome. It's over to you.
Thank you very much for this warm welcome, Professor. And thank you very much for the GRC for organizing this very pertinent conversation and for inviting me to reflect on obligations in relation to sexual and gender-based crimes in the Ukrainian conflict. I'm just trying to set up my screen, so bear with me. Yes. Similar to the previous speaker, I will, in my presentation today, strive to highlight the obligation of the Ukrainian government in relation to persons who were victimized, including in acts of sexual and gender-based crimes. I will not so much focus on the obligation of the conflict's parties to take measure to prevent sexual violence, and instead, I will focus on an area that is subject to research and a study that I'm working on with the Global Survivors Fund, which is focused on the right of survivors of conflict-related sexual violence in Ukraine to a remedy, and specifically to reparations. Unfortunately, there's still a lot of misunderstanding around conflict-related sexual violence, including around its definition. Often it's understood as rape only, and only as an issue affecting women. So I just wanted to put a definition on this term. Conflict-related sexual violence are incidents or patterns of sexual violence that include rape, sexual slavery, forced prostitution, forced pregnancy, enforced sterilization, or any other form of sexual violence of comparable gravity that occur in conflict or post-conflict setting with a direct or indirect link to the conflict. These crimes can constitute war crimes, crimes against humanity, acts of torture, or genocide. And of course, they can be committed against men, women, girls, and boys, but also against gender non-conforming persons. In our research that is focused on conflict-related sexual violence in Ukraine, which is what I would like to focus on in today's presentation, we really pay attention to the gendered nature of the commission of conflict-related sexual violence, particularly in conflict settings. Often, and not only in Ukraine, conflict-related sexual violence is almost always gendered and deeply rooted in gender-based discrimination and gender stereotypes. In addition to the commission of sexual and gender-based violence, sexual violence being gendered, the impact of it too is gendered. But I also want to say that there are other elements to consider, not only gender, when analyzing crimes and assessing the harm. And therefore, an intersectional approach should be applied to the analysis of conflict-related crimes, including sexual violence, that considers any grounds that have played a role in the targeting of persons and may have impacted the harm that they experience. For instance, in our work, we pay significant attention to other grounds that aggravate the situation of survivors and play the role in their targeting, whether that is their political affiliation, actual or perceived, but also their demographical background, which includes their language, their ethnicity, their religion, and their personal backgrounds as well, their education, their social status, their professions, and so on. And why do we do that? Why is gender and intersectional analysis of crimes, all conflict-related crimes, including sexual violence, so important? Because they help us in understanding the harm suffered by survivors and in understanding how they can access the right to a remedy, and what modalities do we have to consider in enabling survivors to access remedy and reparations. Coming to the Ukrainian context, I can perhaps argue that the topic of conflict-related sexual violence is also somehow neglected or does not receive attention in a similar way that other more visible crimes receives attention. For instance, perhaps detention can be more visible than conflict-related sexual violence. Additionally, we are also confronted with the absence of data. We don't know the exact scale and scope of conflict-related sexual violence in Ukraine. There are no numbers of cases or survivors, and this absence is confirmed in the current Ukrainian National Plan for the implementation of Security Council Resolution 1325 on women, peace, and security. But this is not an issue unique to Ukraine. In fact, in most conflict situations, it's really difficult to measure conflict-related sexual violence in a numerical figure. This is somehow related, of course, closely related to the underreporting of conflict-related sexual violence, which is due to different reasons, numerous reasons, including the trauma suffered by survivors' reluctance to speak, due to fear of stigmatization or reprisals, but also due to the lack of pertinent services that would enable them to speak. Additionally, lack to access to the locations where this type of violation and crimes have happened, or where survivors reside, also does not aid in documenting this type of violations and crimes. This is, for instance, the situation of Ukraine, where access to territories controlled by so-called people's republics and to Crimea is somehow limited. And for instance, United Nations documentation bodies have faced challenges to accessing these territories and to reporting on conflict-related sexual violence specifically. But still, what we know is that conflict-related sexual violence has been part of the Ukrainian conflict, and the documentation by UN reports shows that conflict-related sexual violence has been committed on the territory controlled by the government, in the context of detention, at government checkpoints, as a result of military presence in residential areas, but also in territories controlled by the armed groups in Donbas, in the context of deprivation of liberty, at checkpoints, and also resulting from the armed group's presence in residential areas and other factors exacerbating the risk of sexual violence. As for Crimea, sexual violence there has been very difficult to document due to the lack of access, but there has been few cases documented, particularly focusing on sexual violence committed in the context of deprivation of liberty at the hands of Russia. In light of all this, we must consider the rights and needs of survivors of conflict-related sexual violence. So what happens after the crimes and violations have been committed? In international and regional human rights and humanitarian law, the rights of victims and survivors to a remedy and reparation is enshrined, and this right is now widely accepted by states. The right to a remedy has two components. The first is a procedural right to access and participate in obtaining justice. And the second is a substantive right to redress the harm suffered, so the consequences of the crime. Reparations should be provided by the state for acts or omissions that can be attributed to it, that violate its obligations under international human rights law and under international humanitarian law. It should also be provided by any other person or entity liable for violations of international humanitarian law. However, in the event that parties liable for the harm suffered are unable or unwilling to meet their obligations, states should endeavor to establish programs for reparations and assistance to victims. And this, for instance, is a situation we are confronted with, where it's perhaps unlikely that armed groups in the East or Russia and Crimea will establish reparation programs to provide redress for survivors of conflict-related sexual violence committed by their own forces or groups. And certainly survivors should not be waiting for that willingness and readiness to change. Instead, the Ukrainian government should strive to fill that gap by establishing reparation programs that are inclusive of everyone, regardless the perpetrator. Under international law and practice, reparation must be victim-centric, victim-based, gender-sensitive, adequate, effective, and comprehensive, and tailored to the particular needs of the victim and proportionate to the gravity of the harm. Reparation should also be transformative. And what that means is that if the survivor's status before the conflict was already of systematic disadvantage, what is often needed is that reparations should transform and rectify that disadvantage, which is often the case, by the way, of women and gender and sexually non-conforming persons with a status that is somehow disadvantaged already prior to the conflict. Additionally, global guidance for reparations outlines 5 primary forms for reparation, which seeks to address the harm suffered and restore the dignity of survivor, acknowledge wrongdoing, and implement long-term reforms. Forms of reparation include restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. Unfortunately, the reality is that survivors who often struggle with long-term trauma, insecurity, economic and social disempowerment face significant challenges to obtain justice and an effective remedy, including reparations, to which they have a right. Generally speaking, even when reparations exist, they too often fail to involve, reflect, and address specific experiences, needs, and priorities of women, and adequately respond to their gender-specific harms, and also fail to acknowledge survivors of sexual violence and genuinely respond to the harms they experienced and the ensuing needs. And it is against this backdrop that the Global Survivors Fund was established as an innovative, survivor-centric mechanism whose mission is to enhance access to reparations for survivors of conflict-related sexual violence across the globe. In our work in Ukraine, we have been looking into the status of the implementation of survivors' right to a remedy and reparations. And while the research is ongoing, what I can note is that we have found a prevailing impunity around conflict-related sexual violence in Ukraine, with very few cases, criminal proceeding initiated that look into sexual violence either committed by the government forces or by armed groups. We also found the absence of comprehensive reparation programs or specific reparation programs for conflict-related sexual violence. So what are we working towards? We are working with our partners in Ukraine to firstly acknowledge conflict-related sexual violence and its victims and survivors. At present, there is no acknowledgement of conflict-related sexual violence as a problem. Secondly, we're working to advocate for ensuring effective and prompt remedy for all survivors, as enshrined in human rights law, international and regional. The recent adoption of Bill number 2689 by the Parliament of Ukraine to implement international criminal and humanitarian law into the domestic criminal code is a positive and important step, which enables the prosecution of sexual violence, conflict-related, as a war crime and a crime against humanity. But it also needs to be accompanied by additional steps, including the training of law enforcement agencies to work on conflict-related sexual violence. This includes trainings on the Istanbul Protocol and the Protocol on the documentation and investigation of conflict-related sexual violence. And also, it includes specialized trainings for the judiciary as well on the nature of sexual violence and the evidentiary standards. Another issue to consider is also the gender diversification of the police and law enforcement, especially their agents working with conflict-related sexual violence and other sensitive survivors, which would significantly help in the investigation and prosecution of sexual violence. And importantly, we're working towards advocacy for setting up reparations programs by the Ukrainian government. A discussion should be initiated as soon as possible to design reparation programs for victims of conflict-related sexual violence. This should happen soon before the harm becomes irreparable. End of a conflict, a peace agreement, or the establishment of a truth commission are not preconditions for the establishment of reparations. Prosecution of the crimes are also not essential for reparations. In fact, for conflict-related crimes, including sexual violence, which occur on a large scale, administrative programs for reparations have the potential of being more inclusive and accessible than courts, and of being more capable of reaching a larger number of victims, and of being more victim-friendly as their procedures are more flexible and their evidentiary standards and costs are significantly lower. But this is not to suggest that this should preclude victims from obtaining reparations through courts, as both options should be made available and should complement one another. Ukraine should also hold consultations with affected communities, civil society, and experts before deciding on the format and reach the possible best solution for the Ukrainian context. Survivors of conflict-related sexual violence in particular should be in the driver's seat of this conversation, as they are best placed to identify their needs and which forms of reparations they would like to have in place. And finally, years now into the conflict, we encourage the Ukrainian government to consider establishing interim reparation programs that would address the immediate needs of survivors while working towards full reparation programs to be established, which could in some cases take longer periods. So in the interim, there should be interim reparation programs as well. I think I'm pretty much out of time, so I will stop here, and I'm happy to elaborate on any of the points in the discussion. Thank you very much.
Amal, thank you very much for that very comprehensive presentation that highlighted the difficulties and challenges, but also gave some points of light at the end, which really encapsulates the main thematic of the presentation, which was really the harm and the rights of survivors that you brought to our attention. Right, well, that concludes 4 excellent presentations. And we now have, by my reckoning, 15 minutes to get to the coffee break. One of the most important provisions in the conventions, Geneva Conventions, is humanitarian assistance. And we'll all be needing some of that in 15 minutes' time. So those of you who want to raise questions, I'm actually going to allow the hand to be raised in the bottom hand of your panels. Press raise hand, and I will call upon those of you who raise the hand. But I do want to start with a couple of questions that have been directed to Neve Gordon for his presentation. Neve, this is from Irina Marchuk. Does the use of voluntary human shields make it less of a war crime? The Ukrainian government submitted the communication to the International Criminal Court on the use of voluntary human shields in Crimea during the takeover of a Ukrainian military bases. However, it does not seem that the Office of the Prosecutor accepted this conduct falls under war crimes. So the issue of voluntary human shields versus the idea of war crimes. And secondly, there is a question that's just been posted by Elina Bocheva. Thank you for your presentation, Professor Gordon. The issue of proximate shields, which is the third element in your taxonomy, appears to be very acute in the context of the situation in eastern Ukraine. It comes together with a whole bundle of issues. Apart from targeting, there appears to also be a question of whether parties to a conflict were obliged to evacuate civilians, protect civilian property, etc., etc. This bundle of issues looks like quite a challenge in terms of the investigation and accountability. Could you speak more about particular situations or examples where attempts were made to entangle this sort of knots and to attribute liabilities? Neve, do you want to get us started by responding to those?
So basically, you see, there's a kind of oxymoron in the way the question is phrased, because you're saying they used voluntary shields, the military used, and usually when we talk about voluntary human shields, it's people that are not used by the military, but that volunteer to do it. And 99% of the cases that we have looked at voluntary human shield, it's anti-violence people. It's people that try to stop the violence of both sides, or at least of one side. So it seems to me, but you'd have to correct me because I don't know that case, is that what the Russian military asked Crimeans to volunteer and stand between the forces so the Ukrainian army couldn't fire back at the Russians? Is that what happened?
Yeah. So the Russian military, which were disguised as the little green man, they could take over Ukrainian military bases.
Right.
So in other words, this was staged in order for the Russian military to take over the major military infrastructure of Crimea.
So I would, to be frank, I would need to learn the situation, but what I can answer is this, that actually, in terms of the law, voluntary human shields do not appear in the law. And the reason voluntary human shields do not appear in the law is that civilians are imagined as passive. And if they volunteer, they basically cross the line to participants. And once they cross the line to participants, they can be framed, even though they do not use violence, and even though it's just their body, they can be framed as participants in hostilities, and therefore they become killable. But the situation you describe seems to me extremely complicated, and I'd be happy to look at it. If you can send me something via email, I'd be interested to look at it and see what I can.
Yeah, great. There was a report which was published as well, which is public, so I'll be able to share the report with you. It's very unusual situation as well, which we see in Ukraine. And Wayne, who organized this conference, he also participated in the drafting of the ICC communication. And I think the mainstream position that we had, it doesn't matter if civilians participate voluntarily or involuntarily. What matters is the intent of perpetrator, and this is what makes conduct a war crime. So if the intent of Russian military was to to render the area immune, that would make it a war crime. But we shouldn't be concerned as to whether civilians participated as human shields voluntarily or involuntarily.
Right.
Great.
I'll just say the only thing is that it's very complicated to demonstrate intent, to prove intent, and that's where it becomes problematic, right?
Irina, thank you for bringing that to our attention. Thank you, Neve. Neve, do you want to have a quick response to the notion of proximate shields appearing in eastern Ukraine and the question that was asked by Elina?
So again, I didn't understand exactly. If she could just clarify the question, then yes, I'd be happy to.
Hi, I suspect that even the Mosul example could actually address my question. I'm interested in the aspect of liability and investigation in the context of use of proximate shields.
Okay, so first, I didn't finish my talk, but I just wanted to kind of provoke. But what we found about proximate shields is that proximate shielding is not proximity to the fighting per se, but proximity to irregulars, to non-state militaries. So just as an example, when Israel fires at Gaza, then the Palestinian civilians in Gaza are cast as human shields if they are killed. When Hamas fires at Tel Aviv, and even though Israel's central command center is in the middle of Tel Aviv, also next to civilians, like in the Gaza Strip, if Hamas kills civilians, they are framed as civilians. So only civilians that are next to non-state militaries are cast as human shields. That's we found, and we're talking about millions of people when we look at articles in that way. And in terms of liability, it is about, again, the law does not precede its interpretation and does not precede the interpretation in the conflict zone. So it's all about how the violence has been framed, right? So if the actors managed to convince the international arena that these people were used as human shields, let's say by Hamas or by ISIS in Mosul or by the Russians or Ukrainians, whatever it will be, then the liable party is the side that used them, even if they were not really used, but several apartment buildings away from where the militants were shooting. So what we claim is that it's a lot about the semiotic warfare and not about only the warfare on the ground. It's about who frames and how the situation is framed that determines the liability.
Great, thank you very much, Neve. So I'm going to push us into the coffee break. I've been allowed to do that by the organizers. So the second question now is for Elina from Dr. Antal Burks. Dr. Shyshkina, many thanks for your thought-provoking presentation. I have a question regarding persons living in the territories outside of governmental control. The UN Committee on Economic, Social and Cultural Rights recommended to Ukraine to adopt legislation abolishing the requirement for residents of the non-government controlled areas to register as IDPs in order to access their pensions and other social benefits. How burdensome, Dr. Burks asks, is it to register as an IDP for persons who are living in Donbas, Luhansk? E.g., must residents prove and maintain residency in government-controlled areas and cross into the government-controlled territory every 60 days? Are those national legal requirements conforming to international law, in your view?
The pensions, do we have the legal framework for the proper pension coverage, and whether this requirement to show up every 60 days, whether it is in line with the international law? Well, you know, this is the question that was brought up quite a while ago by the advocates, human rights advocates. And, you know, this sort of limitations are set out by the bylaws. The Ukrainian legislation and the national law does not have the distinction between the citizens and IDPs. So meaning that there is no clear distinction. But the question that you raised pertains to those citizens who are registered as IDPs, but actually they reside in non-government control areas. They reside in occupied territory. And yes, indeed, they have to cross the contact line by the checkpoint in order to have access to their pensions. It means that for them, there are additional restrictions and additional barriers that they have to overcome. And those citizens who are not IDPs do not have this kind of barriers. So if we take a closer look at this situation, this sort of barriers are set out in the bylaws. They are not in line with the constitution of Ukraine, since the constitution outlines the right to pension protection, and constitution also provides for non-discrimination on the place of residence or on the status of the citizen. It means that both IDPs and citizens of Ukraine who reside due to certain circumstances in the occupied territories, as well as citizens who reside in government control areas, are all entitled to pensions equally. Respectively, these sort of barriers that have been created are in contradiction to the Constitution of Ukraine, and they are also contradictory to the international norms for the provision of social protection for IDPs and access to pension. And could you repeat the first question, please?
Yes. The UN Committee on Economic, Social Rights recommended the Ukraine to adopt legislation. And the question was, how burdensome is it to register the IDP?
Well, in fact, our legislation is updated regularly, and in the context of pensions and IDPs registration, this is an issue that is very difficult for the legal practitioners, and it is difficult from the point of view of both laws and bylaws. Even though the court decisions for the IDPs are in many cases are in favor of IDPs. So their motions were sustained. For instance, the motions on pensions being paid, and also the adjustment of pensions rate and paying the pensions that were delayed. But the issue here is with the bylaws that need to be aligned with the laws and with the Ukrainian international commitments. So this is the bottom-up approach. We have the recommendation from UN committee to adjust the national framework that is with the purpose to fulfill our obligation. And yes, Ukrainian government, Ukrainian authorities need to take due consideration of that. But let's look closer at the issue.
Elina,
Is this the matter of the bylaws?
Sorry, can I ask you to wrap up because we've got many other questions I need to transfer.
Well, in fact, that's it from me. I would like to say that in many cases, the court rulings are in favor of IDPs, and these court rulings should also be taken into consideration by the members of parliament and legal drafters. And now we have the draft law 2083, and it is now subject to the review of the parliament. This is the mechanism for the improvement of pension access, and it also eliminates those restrictions that are in the bylaws.
Thank you so much for that, Elina. We will take a couple more questions I have here. One is to Amal. What would you recommend to survivors of sexual violence? And do you have examples other than Kosovo and Bosnia where the victim of sexual violence receive reparations? Amal, if I can append a question of my own. You mentioned a lot in your presentation about the problems of documentation, but we are now living in a technological age. I mean, one of the reasons why Black Lives Matter has come to the fore is because we have video evidence of police atrocities. So in the context of armed hostilities, is there any chance that we can possibly rely on that? And then there is a question I will invite from a member of the audience. So if you can answer those 2 points.
Great, thank you very much, and thanks for the question from Tatiana, who also wrote in the chat that she is a member of the SEMA network, which is a network of survivors in Ukraine, survivors of conflict-related sexual violence. So I really appreciate this question coming from a survivor and that perspective and urgency in raising it. In fact, what I want to reiterate is that survivors' efforts and lobbying and advocacy around the world in many conflicts have been a driving force for access to justice and for the establishment of reparation programs. We have seen that almost without that, it's very difficult to realize these rights, basically. So I monitor and I interact a lot with the SEMA network, and we partner up with them a lot. And I feel I just want to applaud their power and their organization of themselves as a survivors group. And I want to say to Tatiana, what survivors can do is keep doing what you are doing, and it is our obligation as an international community to support you, and as a national authorities as well, to support you, to amplify your voices, and to make sure that your demands are heard. So I hope actually someone from the Ukrainian authorities is also listening to this conversation and hearing the urgency of the demands for reparation programs that Tatiana from the SEMA network has voiced. And examples other than those in the Balkan region and Kosovo, I want to say that, yes, as I said in my opening, in my presentation, unfortunately, there is no perfect example of a reparation program for conflict-related sexual violence, but there has been examples and programs that look at sexual violence specifically. I want to mention a recent example adopted in Iraq by the Iraqi parliament that establishes, firstly recognizes sexual violence against the Yazidis as a constituting act of genocide, and also sets the institutional framework for financial support and other forms of redress for survivors. There are also other good examples that one can look into and learn from, because they're not necessarily perfect examples, but also in Latin America. There's an example also in Libya where a decree was passed because of course, it can also be that reparation programs are established through a decree as well. But this example of a decree passed in Libya establishing a fund for reparations for sexual violence has not yet been implemented. So even sometimes when you have the decree or the legal and policy framework, if it was not followed by political will and commitment and resource mobilization, it does not materialize in concrete reparations being delivered to survivors. And finally, in relation to your question on the use of digital documentation, I think what is important in conflict-related sexual violence is that what we need to prove is not just the underlying crime. What we need to also prove is the nexus of these crimes to the conflict, or the fact that these crimes were committed in a widespread and systematic manner, so the existence of policies, orders, and so on, but also linkage to the perpetrators. And their digital evidence can be very useful. It can be used, for instance, to document certain locations, to document certain orders if they were recorded. It is now the trend that armed groups like to show off their crimes and not really hide them. So a lot of the crimes are documented in videos, recording, radio channels, and so on. So it certainly can help in the documentation of this type of crimes and violations. And I think I can add that it has also, I know that some groups working in Ukraine on the documentation of conflict-related crimes have also relied on digital evidence.
Wonderful, thank you. And of course, we have to bear that in mind when we think about the ubiquity of the mobile phone as a potential form of testimony for these acts of violence. I think I'm going to wrap up the panel and ask everyone to be back at 9:50 with facilitation from the organizers for that. Dr. Ian Scobie, thank you very much for agreeing to have latitude on the later start. So we'll be back at 50 minutes past the hour. But before we disappear, please join me in the inaudible applause to our 4 excellent presenters for getting the day going in such a profound and meaningful way. Thank you to all 4 of you. And of course, thank you to our interpreters once again. Thank you.